Hey, I'm Nancy Cavey. I'm a national ERISA and individual disability attorney, and I want to welcome you to this episode of Winning Isn't Easy. We're going to talk about the standard of review and why it matters in your ERISA disability claim. But before we get started, I have to give you a legal disclaimer. The Florida Bar Association tells me that I have to give this legal disclaimer. It's not legal advice. This whole podcast is just my thoughts and commentary. But am going to, in this process, give you a overview of what's happening in the disability insurance world, the games the carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, you have heard me mention the standard of review in many podcast episodes and YouTube videos, but it's time that we dedicate a whole episode to discuss what the standard of review is and why it's important. So the topics are going to be disability plan documents matter concerning the standard of review that courts will use to determine whether your benefits have been correctly denied or terminated. We're next going to talk about, can a disability carrier plan's failure to reference specific plan provisions change the standard of review? And I'm going to talk to you about the 11th Circuit's standard of review in a de novo case. And that's important because the alternative standard of review is something called de novo standard of review. And that's all important. And it's one of the first things I always want to know when I'm looking at a case and talking to a prospective client. Let's take a break before we get started.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Disability plans and documents matter when it comes to the standard of review. And this is what a court is going to look at in determining whether or not your claim denial was correct. That's the theme of this portion of our podcast, because unfortunately many ERISA disability policies or plans have what I call a get out of jail free card. That jail card, if you will, get out of jail free card, handcuffs a federal judge's review of a disability insurance claim denial or termination. That standard, that get out of jail free card, is called arbitrary and capricious, and it favors the insurance company. Now, as a disability policyholder attorney, I would prefer a de novo standard of review. That means that a federal judge isn't bound by the insurance carrier's denial. They can use their own independent judgment to see the games that disability carriers play and use to justify a claims denial or termination. Now, sometimes, I'll read a policy or a plan and the language is clear. I know what it says, but there are other times when there's conflicting language and you don't know what the standard of review is. That is what happened in the De Cristofaro versus Life Insurance Company of North America case. It's a case out of Rhode Island, and I think it's instructive because it talks about both kinds of standards of review. Now, De Cristofaro argued that the standard of review should be de novo, obviously favorable to them, while Cigna, of course, argued that the standard of review was an abuse of discretion and that was the handcuff on the federal judge. So what did the court do? How did they go about resolving this conflict? Well, the first thing they do is they look at documents. We're lawyers and we don't want to look at documents because documents are binding. The court started by determining what documents it was going to look for. And documents, as I think, make all the difference. And they looked at two documents. One was the group policy and the other one was the group long-term disability insurance certificate. Okay. Now, language matters. The group policy said it was the sole contract, and the certificate of insurance said it's not part of the plan, it's not part of the insurance contract. Guess where the discretionary language was that Cigna was relying on for its argument that there was an abuse of standard of review. Guess what? It was in the certificate, which was not part of the plan. So as a result, the court said, hey, the correct standard of review is de novo. Now, that's also important because, as I said, this does not handcuff the judge, and the judge can apply their own independent judgment. There are also situations in certain states where they have banned discretionary clauses. That means that a disability carrier or plan can't put in the policy or the plan this abuse of discretion standard of review. And I love it when I have a client who's in a state that prohibits these types of discretionary clauses, because, I'd rather have the judge look at this with a fresh set of eyes than having to look at it with a set of blinders on and handcuffs. Now, in this case, the court said, look, the correct standard of review is de novo, and even if the policy had discretionary language, we would not have allowed that to be used because there's a ban on discretionary clauses in Rhode Island. So it was going to be de novo, de novo, de novo. The intent of a discretionary ban is to provide a more balanced and even relationship between the insurer and the insured. And that's really, in my view, an understatement. The de novo standard of review starts to level the playing field, where an arbitrary and capricious standard of review is like trying to climb up a greased pole. I want to contrast what happened in the Rhode Island case with what happened in a case called Murch versus Sun Life Insurance. And this is a case out of Illinois. And once again, the issue was, what's the standard of review? Sun Life argued that the policy had a clause providing Sun Life with the entire discretionary authority to make all final determinations regarding claims for benefits under the benefit plan insured by this policy. And that language made this a deferential review, arbitrary and capricious standard of review. Now, on the other hand, Murch gave the court 3 reasons to support an argument for a de novo standard of review. The first one was, look, Judge, I'm an Illinois resident. Illinois regulations prohibit discretionary clauses for policies or plans issued in Illinois. Number 2, there was no discretionary language in a plan document called the summary plan description. And number 3, there was no evidence that his employer had delegated authority to Sun Life, so there was an inadequate delegation of authority to Sun Life. Now, these are common arguments that we make as plaintiff policyholder lawyers. Unfortunately, in this case, the judge looked at each one of these arguments and shot them down. And in this particular case, the plan stated that it was delivered in Florida and subject to the rules of that jurisdiction. And sad to say, Florida does not ban discretionary clauses. Secondly, the policy clearly included a discretionary clause, and Sun Life's failure to include that in the summary plan description didn't matter. It's the policy or plan language that matters. And I will tell you that not all courts are of that particular view. And then the court said, look, I think this policy expressly delegated authority from the employer to Sun Life. You can see, or hear, if you will, that the right words in the right place matter. And each policy or plan and the plan documents have to be analyzed for those words, the location of the words, and be read together to determine what the right standard of review is. And unfortunately, in Murch's case, the court found that it was governed by the arbitrary and capricious standard of review, which means most likely Murch lost his case. Got it? Even us lawyers have difficulty figuring this out, but you've got a great baseline for understanding the difference between discretionary review and de novo review. Let's take a break and give your brain a rest, okay?